Hi, I'm attorney Andrew Thompson at the Thompson Law Office in Carmel, Indiana. We represent people around the state of Indiana in jury trials and other matters involving employment issues and employment law, whether it's a covenant not to compete, trying to enforce non-competition, issues involving trade secrets, or what I'm going to talk about in this segment, wage claims. If you are or have been an employee of an employer, you're entitled under Indiana law to the wages that you contracted to receive. These could have been contracted verbally, or typically in some way they're documented in writing, usually by your HR department, perhaps an offer letter, or maybe even a written comprehensive contract for employment. If that's the case, there are timetables upon which an employer must meet its payroll. Now, the interesting thing with wage claims is that they typically arise because an employer refused to pay a portion of wages due. This could be for a bonus, a commission, or even contracted wages for availability for work. Okay, if you're required to work a job because of the nature of that job, say it's an emergency room in a hospital, where you may have to be available more than 40 hours a week, you can sign a contract with your employer to work additional hours and to be available to work for that time. If you make yourself available for work during a time that you've contracted to be paid, and that contract is in writing, of course you're entitled to payment under the terms of the contract. Interestingly, however, under Indiana law, whereas enforcing payment for a contract, let's say it's for contracted labor in a home, if you have a painting contract, even if you have a contract to do something like mechanical work on a vehicle, if all you have is a contract for your labor as an independent person, an independent contractor, then you're entitled to what you contracted to be paid pursuant to the terms of your agreement as they're written. But if it's a wage claim, if you are treated as an employee and you have not been paid the wages that are due by your employer on a timely basis, in that case, and in that case only, you're entitled to damages that go beyond the actual wages, the actual amount of the contract itself. This is to give employers a clear message, a clear incentive to pay wages that are due in accordance with ordinary payroll so that the lives of their employees don't get disrupted. So if you have unpaid wages on a contracted basis, then you are entitled to receive those lost wages plus double that amount, so it ends up being 3 times the original amount of the wages that were due, plus the reasonable amount of attorney's fees you would incur in order to recover those lost wages. Again, I'm attorney Andrew Thompson with the Thompson Law Office in Carmel, Indiana. Our phone number here is 317-564-4976. If we can help you with a wage claim or other employment-related issue, please call our office today and schedule an appointment. Thank you.